started on our last panel of the day. We're going to, thanks for sticking with us. We are going to be discussing the role of courts in elections, and primarily focused on, I just got much louder. We're going to primarily be focusing on tomorrow's Supreme Court arguments in Moore versus Harper. My name is Zach Montalero. I'm a reporter at Politico, and I'm going to be emceeing this panel, and I'm excited to be joined by a great group of panelists. First to my right, Ben Ginsberg, who is the Volcker Distinguished Visiting Fellow at Stanford Hoover's Institution and co-chair of the Election Officials Legal Defense Network. Ben is best known for practicing election law for 38 years, representing Republican candidates and party committees. Next to Ben is Karen Brinson Bell, who is the executive director of the North Carolina State Board of Elections and has served in that position since June 2019. She has worked in election administration since 2006 in county, state, and national roles. As North Carolina's chief elections official, she leads about 65 full-time employees at the agency, which is charged with administering elections and campaign finance compliance, overseeing the 100 county boards of elections, and ensuring voting for more than 7.4 million voters. Next is Danielle Holley, the dean of Howard University School of Law and a scholar on civil rights and education law. She holds a BA from Yale University and a JD from Harvard, and clerked on the Fifth Circuit Court of Appeals. She joined Howard in 2014. And last but certainly not least, Michael Thorning, the Director of Structural Democracy here at the BPC. He's an author of a recent BPC report, Independent State Legislature Theory Undermines Election Principles. So that is primarily what we're going to be talking about today. The big thing, the big setup is in about, 20-ish hours, maybe a little bit less than 18, the Supreme Court will hear the case Moore v. Harper. At its core, it's a case about redistricting in North Carolina over what maps North Carolina will have. But beyond that, it's testing out the relatively novel legal theory called the Independent State Legislature. I'll give a brief explanation of that and then turn it over to the actual attorneys who can say a little bit more about that. But broadly, what the ISL is a theory popular among some, but not all, conservative lawyers and groups that argues that the election clause in the U.S. Constitution grants state legislatures pretty broad authority to set election rules that can be hemmed in by the federal government, but arguably, in the proponent's view, not by state courts. So what's at issue here in North Carolina is that the legislatively drawn maps there, which were drawn by the Republican-controlled legislature, were struck down by state courts, and eventually a state court map was in place for the 2022 election. This case tomorrow will decide not only the future of North Carolina's maps, which if you're even a little bit familiar with redistricting, you know that it's been a busy time for North Carolina over the past decade, but also the broader purchase of this state, independent state legislature theory. So Ben, I'm going to go to you first, just broadly, what are the tenets of this theory, and talk through your brief in the case, which we'll find out pretty quickly. It's not a theory you agree with.
It is not a theory I agree with. Thank you for having me, and thanks for putting on this discussion at a rather interesting time that we've got. Look, tomorrow's argument will be about two opposing views of the U.S. Constitution. Let's just note that the North Carolina legislature's position is not the way the Constitution's been interpreted for the last 230 years. So in that sense, it is not at all conservative. And in the sense that one of the ramifications of the case will be turning a flood of litigation, especially pre-election litigation, to the federal courts and taking it away from the state courts, if it's adopted, is profoundly not a conservative tenet. It does make sense in sort of the political power dynamics that you've got, in that after the 2011-2012 redistricting, Republicans gained a lot of power in the state legislature. And if you're looking to enhance political power, you play to your strength, and that's the state legislatures. So that's sort of the derivation of it. The brief I wrote was not on the great constitutional doctrine, but rather a practitioner's viewpoint of what would happen if the case is put in place. And it would be a happy time for the Society of Hourly Billers, but probably not good for people wanting to get some certainty in their elections at a time when the system is under considerable amount of assault, as you've heard in the other panels today.
Yeah, elections have become increasingly litigious over the last decade, certainly, the last 2-3 years, more so. So we're kind of driving in that direction. Danielle, I wanted to go to you. Just place this in context a little bit of what we've seen from the Supreme Court on election law over the, this earlier in this term and also the last decade or so.
Great. So thank you so much for having me today. I hope many of you will listen to the oral arguments in Moore versus Harper tomorrow. It should prove to be very interesting. I'll start with my comments the way I typically start in class, which is to read you the part of the Constitution that will actually be discussed tomorrow, since it's a little known part of the Constitution that probably many of us in the room have not spent a lot of time thinking about. So it's Article 1, Section 4. It says, "The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at time by law make or alter such regulations except as to the places of choosing senators," right? So this question of when it says shall be prescribed by each state by the legislature thereof, the question becomes, does the state legislature have total control over redistricting to the exclusion of state courts and the state constitution, right? So who can review the choices that are made by a state legislature when they're participating in redistricting? As been said, this is not something that the theory of independent state legislature theory has not been one that's been ever recognized by the Supreme Court before. So this is a novel legal theory and one I think that is not well supported by the history of this portion of the Constitution. In terms of the overall landscape, I think we can go all the way back to Shelby versus Holder, where we saw the gutting of the Voting Rights Act, and to Merrill last year, and also to other cases dealing with the redistricting, to see that there has been a pretty large-scale attack on the ability to really have any control over redistricting in terms of many communities that feel most vulnerable, right? I think one of the things I'd encourage you to read, if you're gonna read any of the many briefs filed in Moore versus Harper, is the NAACP Legal Defense Fund brief, which does a great job at outlining the many ways in which this case is very dangerous, especially considering the changing demographics of the United States. So in the 2020 census, we saw that states like North Carolina are becoming more and more racially and ethnically diverse. One of the things that can happen is when you have a state legislature that may not be reflective of the demographics of the state, you can see what Lonnie Guinier used to call the possible tyranny of the majority, which is the drawing of districting lines that preserve power in the hands of people regardless of whether they are actually representative of the population of the state, but drawing lines that preserve power in a way that doesn't actually reflect the views of people in the state and can allow certain parties to hold power even if they're actually losing support by numerical support inside the state. And so when we think about challenges and threats to democracy, that's why Moore versus Harper is considered to be part of this challenge and threat to democracy, because it represents the idea that our government may actually be less representative in terms of the views of individual citizens than it has been in the past. So the more that we allow state legislatures to have control, draw district lines without any or very little review by state courts, the question is whether people will continue to have confidence in our elections, whether people will see themselves as represented. Even though they actually go out and vote, will they see themselves as represented by the government that's supposed to be a government of representation?
Yeah, and Daniel, I just want to stick with you for a moment. You mentioned it briefly, but how is this case different from the other redistricting case the court heard 2 months ago in Merrill? I think these are often conflated, but they're very, very different. What's the difference between the two?
Very different. I think so Merrill, when we think about cases like Merrill, you're talking about Voting Rights Act cases, And so this idea that the gutting of the Voting Rights Act, whether we see it in Shelby or in Merrill, is slightly different because we're then talking about interpretation of the Voting Rights Act and how the Voting Rights Act can be particularly protective. In this case, we're not talking about the Voting Rights Act, we're talking about a portion of the Constitution, but the same issue is really at play in the sense that do citizens feel confident in their elections, and what happens when we have extreme partisan gerrymandering, right? So attempts by state legislatures to draw lines, in all parties when they control redistricting engage in partisan gerrymandering. Partisan gerrymandering is a part of the redistricting process. We know that people will engage in partisan gerrymandering, but what are especially the constitutional limits on that, if any, and how does Article 1, Section 4 provide any limits, right? And if it doesn't provide any limits, what are the implications of that?
Got it. Thank you. Michael, before we go to you, I just want a quick plug. We will take questions at the end. If you're listening online, you can either tweet with hashtag Election Summit 20 or 22, or drop them in the YouTube comments, and we'll get to them at the end. Michael, I want to turn a little bit to the structural thing outside of the legal arguments. Let's accept that some version of ISL is going to be accepted by the Supreme Court, just for the sake of this question. Your new report kind of makes it clear where you stand on that, but what is the actual ramifications of it? Why is this not just a theoretical question? What is the actual practical purpose or outcome, even in a modest version of ISL being accepted?
Thanks for that question, Zach. You know, it's not often you get to be on a panel in Washington, D.C. and use the phrase Pandora's box, and I think actually legitimately be correct in using that phrase. I do think this theory really could be that. I think there are, because of its novelty and the relatively thin jurisprudence around it, it's somewhat hard to predict exactly how far the reach of it will go and what all the implications will be. I think if you look to a lot of the legal scholars out there who are speculating about this, there isn't a whole lot of uniformity in how they think it could take shape, which is concerning. You know, we're talking about a major shift. As Ben said, we're going from 230 years of how we've interpreted the Constitution to something new. That's a little different than what we usually expect from the court. Even with some, I think, really you know, major recent cases, you look at, you know, it's hard to think of something more controversial recently than the Dobbs decision. That was something that there had been decades of litigation. This was an issue that had been discussed at length in the public forum. I think this issue is going to catch the public largely off guard, even though a lot of people have very much been trying to explain it. And, you know, it from a structural perspective, sets forth this almost inconceivable idea that the state legislatures will not be bound by the very documents that created them, which is their own state constitutions when it comes to federal elections. I think if the court goes that far, it's very dangerous. When Ben talks about, you know, lawyers are going to be very busy after this, you know, what we worry about is that the targets of that litigation a lot of it could be election officials. Election officials applying the normal discretion that they apply as they run our elections. We know our election codes cannot account for every possible outcome, everything that has to be done. They certainly sometimes can be difficult to predict, you know, emergencies, natural disasters, and that's really when our election officials have to step in and make decisions to ensure that people are able to vote. And I think this will open up a world of litigation around that, and it will be federal litigation, as Ben said, that you know, federal courts basically are going to become the final arbiter of what state election laws say and how they need to be applied. And so you know, we're going to have difficulty with election officials not wanting to either endanger themselves with litigation or making decisions that wind up in court, and there's going to be little recourse from the courts themselves if this theory, at least state courts, will have little ability, as they usually do, to step in and try to remedy the situation. And so in situations where last-minute decisions have to be made, I think it's going to pose situations we haven't faced before, which is who makes the final decision in the breach on election day, maybe in the final hours of an election, about who gets to vote and how.
And this is spawned out of redistricting, right? But your comments were kind of alluding to it, but this could have a much larger effect than just on the lines on which people vote. It could be the rules in which they vote, how election officials process ballots, kind of a wide sweep. There's just, Michael talked a little bit beyond that, beyond just the content of redistricting. What else is in peril in this case? Is it voter-approved initiatives? Is it state boards of elections issuing orders? Is it keeping polls open an extra hour at the end of the day? Beyond redistricting, what are we looking at for tomorrow?
It really could be any of those things. And so, I think you think about in terms of where these protections exist in a number of states. State constitutions across the country protect things like, voter eligibility, whether or not people need to present ID when they come to vote, voter registration standards, early and absentee voting. Essentially, if the independent state legislature theory is embraced, we could see situations where state legislatures decide to pass laws that no longer comport with those state constitutional provisions. And then, we have a situation potentially where you're running one election for federal races with one set of rules, another election at the same time with rules that apply to state elections. And I think to a degree voters have an expectation that their state constitutions apply, and that's what shapes what's going to happen when they go to the voting booth. I think it gives them some expectation that the rules are not going to swing wildly from election to election. I think with the independent state legislature theory, we very much could see a lot of voter confusion about what the rules are, and a danger that Ben brings up in his brief, which is that you could have candidates claiming victory based on two different sets of rules, which I think is even scarier given what we've seen in the last few years.
Yeah, I think one place to watch that is Arizona. I'm not going to get into today, but they already have a very limited bifurcated system, and there are laws being passed now that could expand that. So this is certainly the first word, but not going to be the last. Karen, I wanted to turn to you. You are not a party in this lawsuit, but it obviously affects your job quite significantly, to understate it. So just tell us how, as an election official, how you've been monitoring this case and what you have done. You've been on the periphery of this case. You've signed some affidavits. You've sent things in. So how has this case affected your office so far?
Well, first I'll say the humor's not lost on me that the snack this afternoon is popcorn. I guess we'll have it tomorrow morning too. Yes, I mean, we've been watching closely, and I'm not an attorney. I rely on our attorneys to help me think through what this is about, but as an election administrator, and to have been state elections director while we had 35 lawsuits in 2020, to have been state director when this very case was going through the different levels of the court, and we're in the middle of candidate filing this time last year, and I get a call from one of our attorneys saying, stop filing right now, and I truly ran across an expo hall to a microphone to say, we're stopping filing. To think about that prolonging, we're not at the same place. The Supreme Court's going to give us a decision, but it's going to put us in a place where I think we all have this concern of what kind of litigation do we face, what uncertainty. And in election administration, we rely on certainty. Pivoting on a dime is not an easy thing to do when you have 2,600+ polling places in North Carolina, when you have 25,000 election officials that you are training to be ready for an election, when you have other laws, for example, around felon voting rights and the impact that has even on printing voter registration forms. And if the Pandora's box opens up and you now have conflicts between state courts and federal courts, and then how do we make that happen? That's where I think election administrators are concerned, is it was said earlier today that we keep pulling it off. Well, can we keep pulling it off if there's that much uncertainty, if there's constant litigation, if we no longer have that delegation that's been given to us? North Carolina law has more than 40 sightings in our law of delegation to the State Board of Elections when it comes to federal laws over protests, recounts, ballot design and arrangement, for example. If that can all be up in the air, how do we conduct fair and free elections and make it happen?
Yeah, I'll stick with you for this. Talk a little bit about, North Carolina has certainly seen a lot of changes to its electoral map over the last decade, more so than just ones that most states get to deal with. What has that been like to have to adapt at the last second? And what could, if a robust version of this theory is in place, what could that do to your job, having to react kind of last second to a lot of different things?
Well, I mean, this past year is a prime example. We were in the midst of filing. We got, brand new maps. We had to turn that around in a very quick time frame. And it's not just, there's this belief that you can do an on-off switch in the computer system. It's not that easy. It's coding. It's aligning those maps to precinct boundaries. It's communicating that back out to the voters. The uncertainty of, which district do they even get to vote on, and who's going to be that candidate. That was even a changing complexity. We had someone come and file in a whole different district than they were residing in and representing currently, only to have the maps flipped, and they went back to where they had been representing. And so, there's a lot of moving parts. And, on top of it, it even moved our primary date. We went from March to May. That then affected our second primary dates, which then impacted municipal elections, which, it's not a one and done kind of decision. There's an avalanche almost to it, and it's more complex than I think it's often realized.
Michael, I want to go back to you quickly. One thing in your report that Karen's kind of alluding to is the amount of delegation that actually happens in elections, that state legislatures and governors pass and sign laws that set the top line rules of the road, but many election decisions in states are delegated to state officials, which are delegated to local officials. What could a particularly robust reading of ISL do to that? Like, who would then have to set those rules, and what would happen in an emergency situation, God forbid another pandemic, knock on wood? Who is making those changes? Who's responding to those then, if an ISL theory is adopted by the court tomorrow?
Well, yeah, I think that's what creates the uncertainty. Certainly there is a lot right now that we rely on election official discretion in terms of the decisions they make. An election code, is not an instruction manual down, to all of the steps that you run an election. And so I think what very likely could happen is that state legislatures will really be the only ones who could make some of those decisions. And they may choose to empower themselves to make some of those decisions that otherwise might be left to, either nonpartisan or partisan elected officials. But I think the concern being, for instance, in an emergency situation, either right before Election Day, on Election Day, or some other unexpected event occurs, how are you going to convene the state legislature to clarify what North Carolina state law is? Those are impossible situations, and so then you might have a situation where an election official makes that decision. Could be maybe the Secretary of State, it might be a county election official, and then should that end up getting litigated, what's going to happen to the people who voted under whatever kind of emergency procedures that official set forth. And so those aren't the kind of situations that we want happening in our elections, and I think this would actually encourage that to happen, and not just out of goodwill, but I think people are going to seek to apply this in a way that benefits their political party and then their own political interests. And so we're not just talking about a random situation where an official says, oh, I don't like how this official decided to apply their discretion, it doesn't comply with our state law. I think more likely they might look at the outcome of the election and say, hey, I'm losing. It's probably because I don't like how this went, I'm going to challenge this in court. So I think it mixes up people's partisan incentives with the steady professional decision-making of election officials. And then it adds in the fact that the state legislatures might be sort of the last resort. And are they really capable of, legislatures are slow, deliberative bodies generally, some more than others, but how are they going to make these snap decisions that we have successfully left to election officials? And then sometimes those cases do end up in court, and judges step in and provide some sort of remedy. But I don't know that a legislature is really an ideal body, given its slowness and the political incentives to make those decisions in a snap moment.
Yeah, I'll just note that some state legislatures are not full-time. In fact, many of them are not, to the extreme, like a Texas, which meets absent special session every 2 years. This was a wild thing for me to learn growing up, and I assumed lawmakers did their job year-round. Not true. So we are rapidly approaching question time that I'll open up to the audience, but I do want to go down, at least starting with the attorneys, and Karen, Michael, if you want to weigh in as well. What are you going to be watching for tomorrow morning when arguments kick off? They kick off at 10 a.m. You can watch them on C-SPAN or your favorite platform, wherever, I don't know. But what are you going to be watching for tomorrow, Ben? Are there any justices you're going to be keying into? Any arguments you're going to be listening out for?
Well, what I'll be looking for is that I think the argument in the court will be very much about constitutional doctrine. And so what and I think you know what those arguments are in advance. What I'll be interested in is if any of the justices somehow ask about the practical implications of what they might do. Now, I do think justices only look at practical implications when they're alone at night in their studies and they take a little peek at what might happen in the real world if they pass these things. But between allowing an unchecked branch in a state legislature and all the ability for a majority to preserve itself, the implications of the caseload of federal courts, because I do think that all practitioners will take everything they don't like to federal court, especially the closer you get to an election, which is contrary to this principle the Supreme Court's been trying to invoke, called the Purcell line of cases, to stop last-minute election litigation. Those are some of the practical things that I think it'll be interesting to see if it seeps into the oral argument.
Danielle, I'm going to turn the same question to you. What are you listening for tomorrow? Any justices, any big themes that you're going to be keeping an ear out for?
Yeah, I think similarly, I'll definitely be looking for what Matt has been described as the parade of terribles, right? Them kind of asking lots of questions about beyond redistricting, what are the implications of this case, and does it really lead to, if we support a very robust version of this ISL theory, will it lead to the kinds of things that we have heard on this panel? If you've been paying attention to oral arguments this term, yesterday, and I think in the affirmative action cases, we've heard a lot of spinning out of hypotheticals that don't have a lot to do with the actual factual record in the cases that they're deciding, right? So I'm expecting more of that tomorrow, hearing the justices ask a lot about hypotheticals, probably a lot of hypotheticals related to election administration beyond the redistricting questions that are specific to this case. I think the other themes that we're likely to hear are about separation of powers, and now at the state level, separation of powers. So what does it mean to empower one branch, the legislative branch, at the state level more so than the executive or the judiciary? So I think questions about separation of powers, and then lots of questions about federalism, right? And these questions about how do federal courts interact with all of these questions related to state elections. And we know that in the area of redistricting, the Supreme Court has gone in the direction of saying federal courts have less, I think it was called the Rubuck case from 2019, from 2019, where they talked about the limitations on federal courts. Doesn't apply generally, but I think those questions about separation of powers at the state level and then the relationship between the federal government, federal courts, and what happens in state elections, those two things will also, I'll be watching for that too.
Got it. Karen, Michael, I'll open this question to you briefly before we turn to the audience. If you guys had any thoughts as practitioners, or Karen, in your case, a practitioner, Michael, as a thinker, what you guys are going to be watching for tomorrow. Karen, I'll start with you.
I think you've touched on several of the things that I'm most interested in is, how broad is this discussion? Do they look at some of the practical aspects? And we, whether it's the Supreme Court or a federal court or a state court, we just sit and wait because, it's our job to administer what the law allows. And if that's the direction, no different than we got a federal court decision that told us we had to turn around something in 21 days in 2020. That's what we'll be prepared to do.
And Michael, our thinker, what are you watching for?
I think one big thing has to do with how the court would square this with some of its other precedent. Ben brings up the Purcell principle, but I think the court, for instance, has recognized the legitimacy and authority of voter-enacted initiatives to shape voting and election policy. The court has, for a very long time, recognized the role of state courts in these decisions. How you square this suddenly with this new theory that would endanger both of those possibilities. I think we think about a situation, we've had states enact constitutional amendments or laws through initiative by voters, sometimes over the inaction or objection of their state legislatures. And, I think it calls into question what the, guardrails of American democracy are. Are states that have these initiatives, are the people able to affect their own elections in these states, or are they just subject to the whim of unchecked state legislatures at that point?
Yeah. Thanks, Michael. We have about 10 minutes for questions. I'll prioritize people in the room, but I have a couple on my phone, so just raise your hand. I see one, and then we'll go over here.
Hi, good discussion. Andy Craig at the Rainey Center. There's been a fair amount of discussion about a kind of possible off-ramp for a narrow version of ISL. So even though I kind of agree with you on why it's flawed in first principles, particularly for our litigator on the panel, if you had to make an argument in the alternative for a version that was limited to this kind of scenario where they feel the state Supreme Court has gone too far based on a not specific provision of the Constitution.
Ben, we'll start with you.
So I think that's a really good question. I think the answer to that is they will allow or would allow a state Supreme Court under its state constitution to review a law. I think where courts have maybe gone too far and actually created a lot of work for the Supreme Court is when judges have stepped into the role of a legislature and actually proclaimed a remedy that looks an awful lot like what legislation should be. And so I think the off-ramp may be allowing the review, but not the sort of legislative type remedies that courts have imposed.
So Danielle, if you have anything to add.
No, I completely agree. I think that's the logical off-ramp would be to carve out what would be the things under the state constitution that a state court could review in these circumstances. So that's, I think, the hope I think of many is that instead of getting a very broad interpretation, that if there is going to be an acceptance of this doctrine, that it's a limited recognition.
I'll just do a brief plug for a story I wrote this morning because I'm MC and I can do that. Is that there's been several justices are still up in the air on where they're going to land. Justice Roberts, Amy Coney Barrett, and Justice Kavanaugh. So if you're looking for tomorrow on if there may be that off-ramp, those are the three justices to kind of key in on. The three liberal-leaning justices kind of suspected they will not support the ISL theory. The remaining three conservative justices have all signaled at some point support likely for a more robust version of the theory. It remains to be seen, but at least in some shadow docket writings, they've done that. So that's where to look tomorrow for that off-ramp if it's going to come. I think we have one question over here. Yeah.
Chris Thomas from Bipartisan Policy Center. So under the assumption that the legislatures do ascend, become like election directors, right? What does that do to Congress, to the fight for Congress? Because the way you overrule all these various states is if your party controls Congress. Does that now become a guardrail? Does that now make H.R. 1s more than just a wish list? That if you can get control of the Congress and the presidency, you start doing wide-scale election legislation because of what may be happening in the states under this policy.
Michael, why don't we go to you on that one?
Yeah, two sort of views on what happens with Congress. It of course is going to depend on how that legislation gets enacted. It's been very difficult to enact voting legislation in Congress in recent decades. And so, would a party be tempted to nuke the filibuster to get done what they want to do? Then you might actually end up with a lot of policy instability where federal election policy is swinging back and forth depending on who controls Congress and the White House. So I think that's a bad outcome. But you're right in that basically federal judicial precedent and law becomes kind of the main guardrail that we have potentially. There's another Congress-involved scenario here that I worry about, which has to do with sort of certification of winners. And if it's up to the state legislature to do that, if they decide to empower themselves with that, despite whatever scheme their constitution might set up, we actually might have some pretty ugly battles in Congress. When what the Constitution says is that each house of Congress is the judge of its own elections. And I think we could see scenarios where state legislatures are tempted, and Charles Stewart's here, who's written a lot about the Federal Contested Elections Act, and I think has some concerns with how that is designed in Congress. But you might have a party in a state legislature who decides to certify a winner that maybe doesn't reflect the vote outcome. And then when that person shows up in Congress, if there's a different party in the majority there, they may decide that they're not going to seat that person, or vice versa, those roles. And so I think the point being that this really actually amps up the incentives for partisan activity to try to benefit yourself and your own party. And with the really close margins we've seen recently, I'd hate to imagine a scenario that is a margin as close as we have now, and the majority comes down to one or two, a few of these contested races, and there's some dispute about whether the legislature acted in a way that was contrary to the state constitution, but was fully in line with the independent state legislature theory.
Great. On that note, if we have one more quick question, we could probably entertain it.
There was someone back.
I hate to do two BPC questions in a row, but I do have one I'd love to hear from the panel about. There's been a lot of really interesting conversation about the media coverage of independent state legislature doctrine and this case, and I'm curious what each of your perspectives is on how the media has covered this and whether there's been an overreaction or an underreaction to the severity of the issue.
Ben, why don't we start with you, because we've talked a little bit about this, especially around presidential elections.
I think the media coverage is reflecting what it hears generally from the community and especially from its readership. And I think that's been probably pretty overhyped. All in all, that I think that if you take the extreme independent state legislature theory, that's really extreme, but I just don't think that the court is likely to get there. I'm also amazed that no one has picked up on the practical ramifications if ISL were adopted. It means that any one-party legislature would basically be able to do a congressional map that nobody's going to ever touch. I'm not sure what Republicans think is going to happen in, say, New York and Maryland and New Mexico. And the full ISL, if it was imposed, would end not only gubernatorial vetoes, but also the authority of independent redistricting commissions, which would unleash California to gerrymander for Democrats even more, and the newly Democratic Michigan, Chris Thomas's Michigan, would be a radically more Democratic delegation than it's been in a long time. Republicans did fine on court cases upholding their maps in 2021, much better than Democrats did. And I actually can see a scenario where imposition of the Independent State Legislature doctrine costs Republicans control of Congress in a decade that's going to be pretty competitive as it is.
Karen, we'll go to you. Any thoughts on the media, except for Politico, of course?
So we've actually, what was that?
I said except for Politico, of course.
Oh, except for Politico. Well, I was going to give you a compliment, but.
Actually, let's hear it then.
Since you excluded yourself. No, I mean, but in reality, our public information officer and I have been, fielding questions from the media. And I think from my perspective, what is, the complexity of what we've outlined here, and that phrase, we're election nerds, we're all still wrestling with what all does it mean. Trying to be in the media's shoes, explaining that to, a public that's not even, civically engaged as well as we would like to, who aren't understanding the nuances of this, who, it's also a time of year where they're captivated with many other things, and aren't always looking to the media, mainstream media, to get their accurate information. That's what's been an interesting dialogue with the media from our perspective, is how to help capture that in a way that is in tune with the everyday person of what could this really mean to them, and instead of them waking up, once the Supreme Court decides, or once those different maps are in place, or whatever it might be, that gives them the reality, and there's no undoing it at that point.
Danielle?
A couple of things. I think first is the idea that it's very difficult for the media to report on complex constitutional law questions. I think it's just difficult to explain them in a way that makes it interesting. I think this case for many, you even say the term independent state legislature theory, people just want to take a nap. I mean, it is not sexy. This is not sexy stuff. I don't think anyone, so the way to make it sexy is to claim that this is basically the end of democracy, right? So there's been some of that kind of hyperbole, but also I think a little bit of underreporting on the more extensive threat to democracy that this kind of uncertainty causes. So when we keep talking about uncertainty and chaos, right? What happens is that the more people believe that elections are not stable, right? That there are different rules for every election, even if we have different rules in the same state for a federal election and state election, that undermines public confidence in elections, which is a serious threat to democracy. And I don't think there's been enough reporting on how the idea that we have all of this litigation and all of this change in the way that we conduct elections is itself something to be reported on. That to me is something that's gotten lost in the kind of minutia of the case, is the bigger question of, okay, if we have the Supreme Court deciding multiple election cases every year that have major implications on the way that elections in the United States are conducted, no one understands who and why certain things are happening, more and more people begin to feel that elections in the United States have no sense of stability and no sense of predictability. And that is very difficult for a complex multiracial democracy like the one that we have in this country.
And Michael, last word.
Yeah, it's hard to add to that. I think everyone really covered the main points. I think I would drive home the fact that this is such a sort of while basic, kind of an esoteric argument about how our Constitution should work. It's so antithetical to how our government has worked that I think it's hard for the media to actually describe it in a way that people, it's really going to sink in what the implications are. And I think it's, you can't understate just, how difficult it already is for the media to try to communicate this kind of issue to the general public in a way that's really digestible and they understand how it impacts their life directly. I think for most people, even if they are paying attention to this, if they're not the most highly politically engaged and media engaged viewers, it sounds kind of distant from them, right? This is a battle over, yes, politics and who has the power to make what rules, but how does that really impact me, I think is such a second and third level part of that coverage that it's hard for, I think, the public to understand how it impacts them.
Got it. On that very cheery note, I really want to thank all four of our panelists, Ben, Karen, Danielle, Michael, for joining me. Thank you for sticking around. We saved the best panel for last. And before we wrap up, I'm going to turn it over to Rachel to say some last words.
Thanks, guys. This is purely administrative. I know I'm standing between the elections community and happy hour, which is a very dangerous place to be. So thank you all so much. You guys stuck around, made it through the whole day. Really appreciate it. I really want to thank the election officials who were present today. I know you've had a long year. Karen Brinson Bell from North Carolina, Judge Choate from Colorado, Natalie Adona from Nevada County, California. I saw there was some Twitter discourse on this. Seth Bluestein from Philadelphia, Monica Holman-Evans from DC, and Tammy Smith from Tennessee. Thank you all so much for being here and for everything you've done for our democracy. Please don't forget to rest, everyone, before next year. We really appreciate you being here. If you were an academic presenter at our poster session and you want to keep your poster, they're downstairs at the registration desk. I hope everyone enjoys their time in DC. Thank you so much, and we'll see you next time, 2024.